Hello everyone, my name is Anisha and I am an intern at LEXIS and Company. Today in this video, I'll be discussing with you all about the concept of judicial separation, and I will also be discussing about the difference between judicial separation and divorce. So let's proceed. Either party to the marriage, whether solemnized before or after the commencement of Hindu Marriage Act 1955, can, under section 10 of the Act, they can file a petition for the judicial separation. After the decree is passed in favor of the parties, they are not bound to cohabit with each other, and it is temporary suspension of marital rights between the spouses. The parties, they remain husband and wife, and thus in judicial separation we can understand that the marriage subsists, but just certain rights of marital rights between the spouses, they just temporarily are suspended. And now if we understand that whether marriage is valid or not in judicial separation, then it is totally valid. The marriage is totally valid even if the judicial separation is allowed. If the parties, they want to resume cohabitation, or the order of the court rescinding the decree then will be necessary in that case. Generally, the court will rescind the decree whenever parties ask for it. If the cohabitation is not resumed for a period of 1 year or more after the passing of the decree of the judicial separation, then any party may apply for the divorce under section 13 1A of the Hindu Marriage Act 1955. Now, what are the consequences of judicial separation? As to what will happen after the judicial separation is done. Like, after a decree is passed in favor of the parties, then they are not bound to cohabit with each other, and they are entitled to separate from each other, and all the basic marital obligations, they remain suspended for the time being, and the marital intercourse is no longer remain enforceable, and the marital obligations and the rights are not available to them. They cannot remarry during the period of separation, and either party may be entitled to get maintenance from the other if the situations get so worse. So if any of them remarries, he or she will be the guilty of bigamy if when the decree of judicial separation is in operation and it is not rescinded at that time. So in event of one of the parties dying, the other party will inherit the property of the deceased spouse. It was also said in one of the cases, like Narasimha Reddy and other versus M. Busamba. Now, what are the differences between judicial separation and divorce? As both are totally different terms and both have totally different implications. We talk about difference between judicial separation and divorce. Then judicial separation, in it we parties for the judicial separation petition for the judicial separation, it is allowed under section 10 of the Hindu Marriage Act 1955, while a petition of divorce is allowed under section 13 of the Hindu Marriage Act for the divorce. Now, in judicial separation, this petition can be filed at any time post marriage. While talking about the divorce, this petition can be filed only after completion of 1 year of the marriage. If we talk about judicial separation, on the one hand, then it is one-step process of judgment. If the grounds are satisfied, then the decree is granted directly. And while talking about the divorce, it is the two-step process of judgment. The first is the reconciliation, and then the divorce is granted. Now, talking about the judicial separation, on the one hand, then it is a temporarily suspension of the marriage, while divorce, it is an end of the marriage. And judicial separation, it is also, they cannot remarry during this period of separation, while after divorce they can remarry, and after all the appeals, if any, they are all set aside, then after divorce and all the appeals, they can remarry. So this was all about the difference between the judicial separation and the divorce. So I hope it was understandable, and thank you for listening.